Good evening and welcome to another video with PRATHAM Test Prep. This is your host Sushila Chaudhary and the segment is called Legal Darpan, and today we'll be talking about the current reinstatement of life sentences of the convicts in Bilkis Bano case. Now, on January 9, 2024, the Indian Supreme Court restored the life prison sentence for 11 men in the Bilkis Bano case, cancelling their early release and emphasizing the grave and serious nature of the crimes that were committed by them. Now, the case involves gang rape and murder of a pregnant Muslim woman and her family during the 2002 Gujarat riots. In 2008, these 11 men were sentenced to life, but they were prematurely released in 2022, causing an outrage. Now, on January 9, 2024, after listening to the case, our Supreme Court reinstated their life sentences, highlighting the gravity of the crime. And this case symbolizes a fight for justice in communal violence and sparks national as well as international debates on handling such cases. Now, coming to get in-depth know-how of this case and what exactly happened. First of all, we're going to see the timeline, then we're going to know about the concept of remission, and eventually we're going to discuss what were the issues raised and what was held by the Supreme Court in this particular case. So, now talking about the timeline, in Feb 2002, Bilkis Bano and her family members left their place of residence after the Godhra train burning to avoid the riots. In March 2002, Bilkis Bano, who was 21-year-old at that time, was 5 months pregnant and she was brutally gang raped, and 14 other family members were killed during this post-Godhra riots in Gujarat. In December 2003, the Supreme Court transferred this case for investigation to CBI after it was handled by the Gujarat police. Subsequently, in January 2008, a special court convicted 11 of these men and sentenced them to life imprisonment for the heinous crimes that were committed. The trial was later moved to Mumbai from Gujarat as the victim was getting life threats. So to ensure her availability and her safety, the Supreme Court moved the trial from Gujarat to Mumbai. After it was moved, a special CBI court awarded life term to all these 11 men, and through the way of appeal, they appealed to Bombay High Court, and in December 2016, the Bombay High Court reserved its judgments on the appeal. But in May 2017, the Bombay High Court upheld the life sentences of these 11 convicts. And in April 2019, the Supreme Court directed the Gujarat government to pay rupees 50 lakh as a compensation to Bilkis Bano in this case. And in May 2022, a Supreme Court bench directed the Gujarat government to consider a plea of one of the convicts, who was Radhesham Shah, for premature release under the Gujarat State's 1992 remission policy. However, in August 2022, these 11 convicts were released prematurely, but not under the 1992 remission policy of the government, but later on the 2002 remission policy. Now that particular policy was comparatively more lenient. Now, in November, so after they were prematurely released in August, on 15th of August 2022, the Supreme Court sent notices to the state government, the central government, to get to know about this. And in August 2022, a lot of PILs were filed on Bilkis' behalf. In November 2022, Bilkis Bano then moved the Supreme Court against the Gujarat government's decision. And in August 2023, the Supreme Court began the hearing, and in January 2024, or 9th of January 2024, the Supreme Court caused the remission and ordered the 11 convicts to surrender to the authorities within a span of 2 weeks, emphasizing the grave and serious nature of the crimes committed. Now, talking about remission. Remission basically is the reduction of sentence without changing its nature, allowing for complete ending of a sentence at an earlier point. Unlike furlough or parole, it does not provide a break from prison life. breach of remission conditions can lead to its cancellation, requiring the completion of the original sentence. Constitutionally speaking, both President and Governor in India have the power of pardon under Article 72 and Article 161. So the power presented to the President is under Article 72 and the power with the Governor is under Article 161 respectively. The President's pardoning authority is broader than that of the Governor, and statutorily speaking, the Code of Criminal Procedure grants the appropriate government the power to suspend or remit sentences under section 432 and to commute sentences, that is, to shorten the sentences, primarily enabling state governments to release prisoners before completing their full terms is provided for in section 433. So constitutionally, the power of remission is been given to the particular governor of that state and the President under Article 72 and Article 161 respectively, and pardoning power have been given statutorily in your CRPC under section 432 and section 433. Now there are certain important judgments regarding remission. So first one that we'll be discussing is Lakshman Naskar versus State of Bengal. Now in this particular 2000 judgment, there were factors given that govern the grant of remission. Now these factors include whether the offence is an individual act of crime without affecting the society at large, whether there is any chance of future recurrence of or committing of this offence. Now whether the convict has lost his potentiality to in committing those particular kind of crimes, whether there is a fruitful purpose of confining the convict anymore, and socio-economic conditions to the convict's family. Now the reason these grounds have been set is because we see remission as a right of the convict. So before granting that person, because these rights are not inherent, so before granting these particular rights to a person, a right of liberty from the jail, these certain factors have to be taken into consideration and have to have a positive outcome as a result. Now the second case which was even taken into consideration in this particular case that we are talking about, it is Ipuru Sudhakar versus State of Andhra Pradesh. Now this judgment was delivered in 2006. In this, the Supreme Court held that judicial review of the order of remission is available only on certain grounds. Now the grounds that were mentioned by the Supreme Court are non-application of mine, the remission order that was given was malified, the order has been passed by an extraneous or wholly irrelevant consideration. So basically the consideration that have been given in the case of Lakshman Naskar versus State of West Bengal have not been considered. Relevant materials have been kept out of consideration, and or the order suffers from arbitrariness. Now let's come to the what were the issues raised in this particular case of Bilkis Bano. So in the case of Bilkis Yaqub Rasool versus Union of India, so Supreme Court rendered a comprehensive judgment and it addresses the 5 issues that were presented before the court. First of all, the first issue talks about the maintainability of the petition under Article 32. So whether the petition filed by one of the victims in the case is maintainable under Article 32 of the Constitution or not. The first issue revolved around this particular thing, that can the victim file a case under Article 32 of the Constitution. The court emphasized that the right to file a petition under Article 32, which deals with fundamental rights, is itself a fundamental right. Bilkis Bano invoked Article 32 to enforce her fundamental rights under Article 21, that is right to life and liberty, and under Article 14, that is right to equality and equal protection of law. The court in this particular issue ruled that the petition under Article 32 is clearly maintainable considering the object and purpose of Article 32 as the enforcement of other fundamental rights. Now, the next issue raised was maintainability of PIL challenging the remission orders. The court, while acknowledging detailed submission on the maintainability of PIL, did not find it necessary to address this issue separately because Bilkis Bano had already invoked Article 32. The court deemed the consideration of PIM maintainability as academic and not requiring a separate determination. Now coming to the third issue that was raised, that was on the competence of the government. So competence of the Gujarat government to pass this remission order, does it have the competence or not? And this was the central issue that in this case. So the central issue in this particular case revolved around whether the Gujarat government had the competence to pass the remission orders or not. The court scrutinized section 432 of the CRPC, highlighting that while section 432 clause 1 empowers the appropriate government to suspend or remit sentences, section 432 clause 2 imposes a crucial condition. According to the section 432 clause 7, the appropriate government is the state government within whose jurisdiction the offender is sentenced. And in this particular case, since we saw that there was a special CBI court in Maharashtra which gave the particular judgment, the case was transferred from Gujarat to Mumbai back in its day. So in this case, particularly Maharashtra government will be considered as the appropriate government. The court held that the Gujarat government had no jurisdiction to entertain remission applications as the trial occurred in Maharashtra. Consequently, the remission orders were declared illegal and quashed. The next issue raised was regarding the legality of remission orders. The court determined that the remission orders passed by the Gujarat government were not in accordance with the law for several reasons. These included the Gujarat government's usurping the powers of state of Maharashtra, inapplicability of 1992 policy of remission to the case, rendering the opinion of the presiding judges ineffective, overlooking the facts that the convicts hadn't even paid the fine ordered by the special court in Mumbai. So these were the reasons why the order was not legal. Was these factors that first of all Gujarat government was not the appropriate government. Secondly, there was the state policy of 1992 was inapplicable, and the opinion of the presiding judge. So the opinion of the special court in Mumbai. He was asked for his opinion back in 2019, and he had a negative report towards this. Then additionally, the fact that the convicts have not even paid the fine ordered by the special court of Mumbai. Hence, these all reasons make the remission orders illegal. Lastly, the issue raised was about disposition of the convicts after the remission quashing. The court faced a delicate question of whether the convict should be sent back to the prison or given a benefit of liberty. While acknowledging the importance of balancing the rule of law against individual liberty, the court concluded that the rule of law must prevail. Consequently, the court directed the convicts to report to the concerned jail authorities within 2 weeks from the date of ruling. Now, in summary, the Supreme Court's ruling in the case of Bilkis Yaqub Rasool versus Union of India clarified the maintainability of the petition, addressed the competence of the Gujarat government to pass remission orders, and ultimately quashed the remission orders, directing the convicts to return to the prison in adherence to the rule of law. So that was all from our side regarding the Bilkis Bano case and the petition of the 11 convicts as well. There are a lot of options that these convicts can still avail. So basically, either they can go to the Supreme Court with a review petition, or they can file a new fresh application for remission. So that was all from our side today. Thank you so much for watching, and for more such content, please subscribe to the channel, and if you like the content, please like, comment and share with your friends. Thank you.